Welcome to part three of chapter two. This is Dr. J. Kent Gregory again, and we will wrap up chapter two with a discussion of how cases proceed to and through the Supreme Court. So, chapter two, the court system. So, when a petition for writ of certiorari is filed with the Supreme Court, the party that won the case in the appeal files an opposition to it. So the loser or the losing side of a case will write the or submit the writ of certiorari, and then the winner of the case will file an opposition to that. So there's the rule of four. This is a Supreme Court rule where only four justices are needed to agree for a case to be heard by the full court. So in a term, each Supreme Court justice is permitted to hire up to four law clerks for assistance. And then a related concept is the cert pool, which is, the short for the certiorari pool. Many justices rely on their clerks to read the thousands of filed petitions and to make recommendations on whether or not to grant the case. And of course, those clerks typically come from, the top law schools in the United States. They're fairly recent or very recent graduates. Uh, if a petition is granted, the parties are then instructed to file written briefs with the court, and the brief lays out why their side should win. And at this point, the court allows non-parties to the dispute to file an amicus brief. An amicus means in Latin a friend. So an amicus brief is filed to, sum it up, is filed by the non-litigants with permission of the court to inform and persuade the court itself. This is otherwise known as a friend of the court brief, but an amicus brief. So the Supreme Court's process. So after the justices have read the briefs in the case, they hear oral arguments from both sides. After the oral arguments, the justices meet in conference to decide the outcome of the case. Now, during the oral arguments, the justices, have the opportunity to question the attorneys for each side. So justices work alone in their conferences, and then the task of drafting legal opinions is initiated after deciding which side should win. So types of opinions. So the opinions are the only way that justices communicate with the public and then the legal community. So there's the majority opinion. This is the opinion of the court, written by a single judge and joined by other judges who voted the same way. So this would be the five judges who, were party to the majority vote. A dissenting opinion. This is an opinion of a judge who disagrees with the outcome and reasoning employed by the court majority. And it exists out there to, one, state, an alternative view of the case and can be cited, and oftentimes will be cited in other future cases that are similar. So it's possible that the dissenting opinion may ultimately give birth to, for lack of a better expression, but give birth to an interpretation of a law. Um, Concurring opinion, this is an opinion written by a judge who agrees with the majority's outcome, but disagrees with their reasoning. So key takeaway. The Supreme Court has discretionary jurisdiction to hear any case it wishes to hear. And every year, the chance of being heard by the Supreme Court is less than 1%. And the Supreme Court usually is more likely to hear a case if it involves an issue of national importance, or if the court believes a lower court has misinterpreted the precedent, or if the case involves a split between two or more appellate courts and appellate circuit courts. And so an appellate circuit split occurs when two or more federal circuit courts of appeals disagree on the meaning of a federal law. And then this then results in the law being different depending upon where citizens live. So that would need to be resolved by the Supreme Court. Although it takes a majority of justices to vote together to win a case, only a minority decides the court's docket under the rule of four. Uh, the Supreme Court decides cases every term by reading briefs and amicus briefs and by hearing oral arguments. Uh, and in any case, the court may issue a majority opinion, dissenting opinions, and concurring opinions. So that's the Supreme Court, and obviously this does have importance for cases that involve not just civil rights, but for businesses. And since this is a business law class, I wanted to draw our focus onto that. So those cases can involve, you know, uh, taxes. It certainly involved an appeal to overturn the Affordable Care Act, uh, which definitely had, you know, important and significant, impacts on the business community, whether they were in, whether the business was an insurer or whether the business was an employer, who then would have, extended responsibilities under the Affordable Care Act. So, food for thought, and thank you very much for tuning in.